How do patent royalties work in licensing? Imagine inventing something that could change the way we live or work. Now, think about how you can make money from that invention without building a factory or selling directly. That's where patent licensing and royalties come into play. When a company owns a patent, they can choose to let others use their invention through a licensing agreement. The licensee, or the person or company using the patent, pays the patent owner, called the licensor, a fee called a royalty. This fee is usually a percentage of the money the licensee makes from products or services that use the patented technology. For example, if a license agreement says a 5% royalty on net sales, the licensee pays 5% of their sales revenue from the product to the patent owner. There are different ways to pay these royalties. One common method is a running royalty, which means ongoing payments based on how much the licensee sells or earns. For instance, a pharmaceutical company might pay a 4% royalty each year on the net sales of a patented drug. Sometimes, there is an upfront fee, which is a one-time payment made when the licensing agreement begins. This helps the patent owner get some money right away. There are also milestone payments, which are fixed amounts paid when certain goals are reached, like getting regulatory approval or hitting specific sales targets. Minimum royalties are another option, guaranteeing the patent owner a minimum amount of money regardless of sales. Calculating royalties can get a little complex. Sometimes, the agreement will have tiered rates, where the percentage changes based on sales volume. For example, the royalty might be 3% for the first $1 million in sales and 5% for anything above that. Deductions for product returns or caps on total payments can also be included to keep things fair. The agreement clearly defines the royalty base, which is the amount the percentage is applied to avoid disagreements later. Deciding on a fair royalty rate involves looking at several factors. The value of the invention to the licensee is important, as well as what similar licenses typically pay. The strength and scope of the patent rights matter too. If the patent covers a broad area or is very strong, higher royalties might be justified. Market conditions and how much demand there is for the product also influence the rate. If the license is exclusive, meaning only one licensee can use the patent, the royalty rate is often higher. Negotiations often use different methods to set the rate. The income approach estimates future earnings from the patent. The market approach compares similar licensing deals. The cost approach considers how much it cost to develop the invention. Legal principles from patent infringement cases, especially the idea of a reasonable royalty, also guide these negotiations. From a legal standpoint, patent royalties are a way to turn intellectual property into income while keeping control over how the invention is used. Licensing agreements must clearly spell out the royalty terms, payment schedules, audit rights to check payments, and remedies if payments are missed or if there's infringement. This helps protect the patent owner's rights and ensures everyone understands their responsibilities. In practical terms, patent royalties allow inventors, companies, and research institutions to earn money from their innovations without having to produce or sell products themselves. Licensees benefit by gaining access to new technology that can improve their products or give them a competitive edge. Meanwhile, patent owners receive compensation based on how successful their invention becomes in the market. Overall, patent royalties in licensing are a carefully negotiated way to share the benefits of innovation. They are governed by legal rules that make sure both sides are treated fairly and that the patent owner's rights are protected.